Good afternoon, everybody, and welcome to It's Time to Get Your You-Know-What Together. We're here today with Samantha Fitzgerald and myself, Bianca Moreras, and our topic today is the misconceptions of estate planning, probate, and trust. And God knows we make lots of mistakes. But before we get started, let me tell you a little bit about Samantha. Samantha is an attorney in Plantation. She is 100% focused in estate planning and probate and trust administration. She's been practicing for over 20 years, and she's a CPA and has her LLM in tax. Say hello, Samantha.
Welcome, everyone. Thanks for coming.
Awesome.
So I got the idea to do this segment because we get the same misconceptions over and over again. So I figured we need to clear them up once and for all.
Awesome. Thank you. And just to let you know who I am, I'm Bianca Moreras. I'll be your host and moderator. I'm a business development and career transition consultant and coach. I bring almost 40 years of experience to the table. I concentrate with lawyers and law firms, and I work to get them to the next level. So without further ado, we are going to get started. So Samantha, let me ask you this. I heard I can give away $10,000 tax-free. Is that true?
I also just wanted to, before I answer the question, mention that if anybody has any questions, you can put them in the chat box if you don't want to ask them out loud, or you are always welcome to, raise your hand and ask questions along the way. So I get this question a lot. Can I give away $10,000? Well, the answer is yes and no. So you can actually give away a little over $12 million without paying any tax. So where the $10,000 thing comes from is we have what I call like a freebie gift. So once a year, you can give away what the federal government calls the annual exclusion gift. And there are some rules around this, but basically you can make a gift of, it's currently $16,000 every year to as many people as you want. It doesn't matter who they are. They don't have to be related to you. And it's every single year. It used to be $10,000 a long time ago, and it's gone up, indexed for inflation. So currently it's $16,000, but the 10,000 is stuck in everybody's head. Sometimes people will say $15,000. So it's true in the sense that, yes, you can make this gift and it is completely tax-free. You don't even need to report it. Now, if you go over the $16,000, you are supposed to report it, and it uses part of your exemption. So right now, the exemption for US people is a little over $12 million. And it's unified between our gift tax and our estate tax. And these are all federal things. So some states also have their own tax rules. Florida has no estate or gift tax. So we're looking at the federal government. So you can give away your entire exemption at one time. You just won't have anything left when you die. So if you die and you still have assets, then your estate will be taxed. But for instance, I could give away $5 million today, and I'm still going to have another $7 million when I die, unless the laws change by the time I'm dead, which will most likely happen.
Okay, well, that just makes me think why so many people move to Florida. They don't have that additional state tax.
No income tax, no estate tax, no gift tax.
Wow. Okay. So that clarifies a lot for me. So can I just cross out something in my will or trust and initial it? Does that work?
No, and more no. We see people do this all the time, and they truly think that if they initial it, it's perfectly legal, and it's not. You have to modify the document and go through all of the formalities of executing that document properly with witnesses and notaries, whatever is required for that specific document.
Okay, so we have to come back and see you.
me or somebody,
Somebody,
preferably
for
me,
sure.
but
Preferably, of course. Okay. So I heard that if my estate goes through probate, it will be taxed.
no, a lot of people think that probate has nothing to do with the taxation of your estate. Certain assets are subject to income tax, certain estates are subject to estate tax. That's going to happen whether it goes through probate or not. The cost involved in probate are the court fees, the legal fees, but there's no additional tax because it went through probate.
Okay. All right. So, but we know probate can last a long time, so it could be costly.
Absolutely costly, you know, because of the legal fees and then, you know, the filing fees and, you know, lots of bad stuff happens in probate. You know, that's where people start arguing and, you know, you're in front of a judge. So you know, sometimes the judge doesn't see things the way you see things, or sometimes, you know, for instance, we had a probate recently and we were trying to sell the car. It's not a big asset. We had to file this petition with the court at least 3 times, maybe 4, because the court kept nitpicking and saying, well, we need this. Well, we need that. Well, we need this. And the process of that happening is you file the petition with the court and then the court rejects it. Who knows when? Maybe a week later, maybe 3 weeks later. In Palm Beach County, it's taking about 8 weeks to get a response on a petition. So imagine you wait 8 weeks, not to get your order, your court order, so you can proceed, but you get a rejection. And then you have to file something again and wait another 8 weeks. So when you're subject to the court rules and being in front of a judge and being in the legal system, everything is slow because like everywhere, everything, anything possibly related to the government is underfunded. So they don't have enough employees, they don't have enough staff, they have too many cases. Palm Beach, Broward, and Dade counties have the most cases filed, I think, than any other county, well, definitely any other county in the state of Florida. So it's just very slow, and there's no set of universal rules. So you cannot say, oh, I want to sell a car, this is what I have to do. Every court is different, every judge is different, and they make up the rules as they go along. And they will look at something, and if something raises a question for them, they're going to ask for something additional. Whereas if you're not in front of the judge, you're not in court at all, as long as you're following the law, you can proceed. So it's much quicker. So you don't want to be in court. So there's no tax, but there's lots of other problems, expenses, and delays for sure.
Wow. Got to get your trust done. That's what that tells me. Is it true that my estate only has to go through probate if it's more than $75,000?
Not at all. We get that a lot. So until recently, with a new law that was passed, I used to say $1 can trigger probate. So probate is triggered by the asset itself. So if the asset doesn't pass some other way, like joint ownership, it passes to the joint owner, a beneficiary designation, it passes to the designated beneficiary. Something's titled in a trust, it's in the trust, it's not owned by you personally. Those things don't have to pass through a probate administration, but everything else does, because it doesn't just pass to somebody else when you die. It has to go through the legal process to get where it's going. So you could have a bank account with $1 in it, and if there's no designated beneficiary and there's no joint owner, it has to go through the probate process. So recently they passed a new law that says if it's $1,000 or less, you can collect that bank account by an affidavit process. Some lawyers are complaining that banks are refusing to follow the law because it's new and they don't really understand it. But in any event, that rule is on the books now. So if it's $1,001, it's got to go through probate.
Wow. Okay. So many things to know. Isn't a trust really complicated though?
Not at all. It seems overwhelming for people because they don't understand it, but it's really no different than a will. You know, it's a document. that says who's in charge of your estate and who gets what. That's it. You know, it's better than a will. It's different. I shouldn't say it's better. You know, you should have them both, but it can do things that a will cannot do, because a will only controls the probate process. That's all it does. A trust will help you stay out of the probate process. And it does a lot of other really great things. So it's very tough for people to understand it for some reason. So therefore they think it's too complicated. I don't want it. But I really encourage everybody to try to understand it. And, you know, maybe you don't understand 100% of everything about it, but you have to find a professional, an estate planning attorney that you trust, and hope that, you know, they're going to do the right thing for you and guide you and steer you in the right direction, because a trust is super beneficial for most people. So I really highly encourage everybody to consider having one, even if you don't fully understand 100%. You should understand it at some level. You know, you shouldn't have all these documents and not understand what any of them do. But a trust helps avoid probate. It provides creditor protection for your beneficiaries. You know, it avoids guardianship for minor beneficiaries. It does lots of really great things, and it's not that complicated.
So Samantha, I do have a question in the chat. Do you have to pay the full legal fee for every change you make to your trust?
The full,
in other words, like whatever you paid to begin with, you pay that
that's a
over and
great
over?
question. That's a great question. Usually not. Sometimes we have clients that come back that redo everything. Even then, we don't charge them the initial thing that they paid, because they're already clients. So we tend to charge them less than we would have charged a complete stranger coming to us. So no, and sometimes the changes are minor. So sometimes the fee is very minor. We actually, you know, we make less money, we do, on our existing clients, because we tend to charge them less than we would charge just a random person coming to us for the same exact work, just because they're our existing clients.
Like family.
But there is a fee typically. So, because I get that question a lot, you know, I'm doing my documents, so if I need any changes, what's the fee? I can't ever quote somebody what the fee is at that time, because we don't know what the changes are going to be. Sometimes they're super minor. They're just changing a name. Sometimes, you know, maybe they're removing one beneficiary and it's still pretty minor, but we have to make the change. We have to, you know, reprint the documents, and they have to come and re-sign the documents. Because remember, we can't make a change by hand and initial the change. We have to actually execute the document again.
Absolutely. Okay. I hope that was a good response for you. So my brother is the designated beneficiary on my bank accounts, but my will says they'll go to my daughter. So she will get them, right? She'll get the money, right?
Nope.
Uh-oh.
So the beneficiary designation comes first. Those assets don't even go through the probate process. Your will only controls the probate process. It has no effect on any assets that pass outside of the probate process. So this is a big one for people. They do not understand this, no matter how much we discuss it in our meetings. The will only controls an asset that passes through probate. So you may own 10 things when you die: piece of property, a bank account, a life insurance policy, who knows what, 10 different things. Maybe 9 of them pass outside of the probate process, and 1 asset goes through probate. The will only controls that 1 asset. It has absolutely no effect or control on anything else.
So in other words, my brother's going to get that money.
Yeah. So if you have that set up, because a lot of people do that before they have children, they have financial accounts and they name their parents, their siblings as beneficiaries, and then they subsequently have children. Their children aren't going to get anything.
Whew. Everybody look at your beneficiaries quick. Oh my goodness. If you have a trust, your estate doesn't go through probate, right?
Not exactly true. So just the fact of having a trust does not keep your estate out of probate. Probate is triggered by the actual assets. So you may have a trust and then do nothing with it. If you don't actually retitle your assets or name the right beneficiaries on your accounts, which may be your trust, a lot of times we're recommending your trust is the designated beneficiary. If you don't do that, nothing gets to the trust. So, the trust is not this magical instrument that poof avoids probate altogether. You have to, what they call, fund it, so you have to actually move the assets. So that's a big one. We spend a lot of time with our clients discussing, once they've signed the documents, we don't just hand them to them and say, hey, thanks a lot, have a great day. We have extensive discussions on what we're going to do with their assets now that we have the documents in place. We help them with a lot of them. So real estate, we help them retitle. Corporations and limited liability companies, we help them retitle. Financial accounts, we have discussions and give them tools and letters in order to help them designate beneficiaries or retitle those accounts into their trust. So most of our clients, should be good, but just the fact that the trust exists is not enough.
Oh, gosh. All right. So lots to do after you make your trust. It's
Yes.
just not poof, like you said. Okay. Is there an annual fee to maintain a trust?
Not with our firm, and I don't think, most lawyers do that, but I get that question a lot. So it's not like a corporation or a limited liability company that gets formed through some sort of state organization. Like with corporations, it's the Division of Corporations through the Department of State. And there's an annual filing fee to keep that entity active. There's no such thing with trusts. They don't get filed anywhere. They don't get recorded anywhere. It's a private document, just like your will. Again, it's really just like a will. It's a document that says who gets what and who's in charge. So it's just a piece of paper.
Okay. So with that being said, if I have a will, does my estate avoid probate? And I think you answered it a little before, but can you elaborate?
Yeah, absolutely not. This is probably the number one misconception. People think if they have a will that they're fine and they don't need anything else and that their estate will not go through probate. But that is just simply false. If you have a probate, your will controls the process, but it doesn't cause you to go into probate and it doesn't cause you to avoid probate. It merely controls the process once you're there.
Okay. So, should I have a DNR?
I get this question a lot. Usually, no, most people do not want a DNR, but they confuse it with a living will. So a living will is the pull the plug document. It says, if I'm being kept alive on machines, on life support, I want to be taken off the machines. A lot of people say, I don't want to be kept alive on machines. A DNR means do not resuscitate. It means if I stop breathing right now, I don't want anybody to touch me and I don't want to be resuscitated. I want to die. That's not what people want typically. Now, if you're very, very old, you're very, very ill, and you are at the end of your life and you truly do not want to live if you naturally stop breathing, then you want a DNR. But most people don't.
Okay, thanks for clarifying that. Oh, gosh. Can't my spouse make financial decisions for me if I'm incapacitated?
Sometimes, but a lot of times, no. So they can with respect to certain joint assets, like a joint bank account. Any joint owner, you may have an account with your child or with your friend or whomever. When you have a joint bank account with someone, either joint owner can access that account 100% typically. Maybe if you have a car and you're both on title, then either one of you can do something with that car. But a lot of assets, you do not get the power to make decisions or to maneuver that asset simply because of your marital status. Examples of that, one is real estate. So a lot of couples own property together. They own a home. You cannot sell your home. You cannot refinance a mortgage without both signatures. And if your spouse is incapacitated and can't sign, you do not have the legal authority to sign on their behalf. This would also be the case with something that your spouse owns individually, like a retirement account or a life insurance policy. If you need to tap into one of those things to get some cash for your expenses, for your spouse's care, perhaps, you have no legal authority to do that. So that's where a durable power of attorney is essential.
Yeah, because you never know what's going to happen, right? You need that.
Nobody knows.
Nobody knows. So I'll ask you, my mom recently passed away, but I have a POA. So can I continue to manage her affairs, right?
We get that question a lot too. Well, actually, people just tell us that they have a power of attorney, so they're going to do X, Y, Z. No, a power of attorney terminates the instant somebody dies. Doesn't matter if you used to have one, you have no more authority to do anything. So a lot of people get caught off guard with this because they're managing mom or dad's bank account and they're paying bills. And then mom or dad dies. And they say, well, how am I going to continue to pay the bills? Well, you're not. You're going to have to pay them out of your own money, or you're going to have to wait until the probate is opened if, you know, there's no beneficiary on the account. Sometimes people are caught off guard where they think they have a joint account with mom or dad because they're able to withdraw money or sign checks. And then when mom or dad dies, they then learn they were only on the account as an attorney in fact under the power of attorney, and it was never a joint account. So I always encourage people to check and verify, because they're just going about their business and doing stuff and it's working for them, you know, so there's no reason for them to question anything. And then they're really shocked, you know, upon mom or dad's death.
Wow, that's scary. Trusts are only for the wealthy, right? Not us lay people.
Absolutely not. Most people can benefit from trusts, depending on your circumstances. If you own a home, you can most definitely benefit from a trust. If you have young children, you can definitely benefit from a trust. Even if you don't own a lot of assets, but you have, let's say, a life insurance policy. So let's say you own nothing, you don't even own a home, but you have a life insurance policy and you have young children. Absolutely, you can benefit from a trust, because you don't want your money, your assets going into a court administered guardianship for the kids. Absolutely not. That's a disaster. And the trust not only avoids guardianship, but it says you get to dictate when the kids get the money. So even if it went into a guardianship and you didn't care about that court process, at 18, they're adults in Florida, they're going to get all the money. You can't stop it. Well, an 18-year-old is a child still. They certainly shouldn't have a lot of money. But the trust also provides creditor protection for the child. It provides protection against their spouses if they themselves are incapacitated or disabled. A trust provides tremendous benefits, lots and lots of benefits. So even if you don't have a lot of money, sometimes a small amount of money or assets can really benefit from a trust. Occasionally, you know, we have clients that they really don't need a trust, but it depends on the circumstances and who their beneficiaries are, who they're leaving things to, and what they own. But it's absolutely not just for wealthy people.
Okay, well, that's great. I want to open it up to the floor. We still have a few minutes. Does anyone have any questions? Because there's no stupid question.
I'm going
So
to
does
say two more
anybody
things,
have?
though. I'm just going
sorry?
to add a couple of things. So this week I had lunch with a colleague, and I was shocked that they told me, because they work in the legal field, I used to work with them, and he said that he had no estate planning done. Nothing. He's been in 2 major car accidents. He's had surgeries. He's not the poster child for health, and nothing, not even a power of attorney or a healthcare surrogate. So his reasons were, and you're frozen, Bianca, so I hope you can hear us. One reason was, if I do a will, I'm going to die. We hear that a lot. you know, I'm not God, so I really can't answer that exactly, but I can tell you out of all of the wills that I've done in my career, it hasn't happened very often. Um, I have had some people pass away shortly after we've done documents, but you know, they were older and you know, some of them knew that they were sick. But in general, your chances of dying right after you do your documents is pretty slim. The other one that he said was, well, I don't have anything. Well, that's simply not true. Unless you're homeless, you have something. Maybe you own a home and that's the only thing that you have. Maybe you don't own a home, but you have something else. A lot of people really think because they don't feel wealthy in their day-to-day life, but if they were to die, all of their assets would be gathered up. Their retirement accounts, their life insurance policies, their home, their cash, their checking account, their investments, everything that they have is all bundled together. Most people have something. Even if you don't have any assets, you definitely need what we call the incapacity documents. So the healthcare surrogate designation, the durable power of attorney, those things are while you're alive to help people make decisions for you if you're incapacitated. You and your loved ones can be in a very, very difficult situation if nobody has the legal authority to make decisions for you while you're incapacitated. So that's a bad position to be in. We don't want to be there. We lost Bianca, so we'll just keep going because we're almost done anyway. We have one more question in the chat box. Older mom with a house and assets. She is worried about leaving us paying death taxes on her estate. So the death taxes, because there's always misconceptions about taxes in general. Florida has no estate or gift tax at all. So there's no death tax in Florida. The federal government, as I mentioned earlier, the exemption is over $12 million. So if your estate is less than $12 million, you're not going to be any tax upon your death until that law is changed, but it will still be pretty high. The only other possible taxes are income taxes. Something like an IRA or a retirement account is always going to be subject to income tax no matter what. And the only other thing is if you inherit an asset and then you later sell it, there can be capital gain tax, which is also an income tax. But those assets get what's called a step up in basis. So if you bought an asset for $1, when you die, it's worth $2. It now gets a new $2 cost basis. So if you sell it for $2, there's no capital gains tax. But if you sell it for $3, there's a $1 capital gain tax. But before death, there would have been a $2 capital gain tax. So it's kind of more beneficial to die because you get that step up in basis, reducing the tax liability for your heirs. Thank you everybody for coming. I really appreciate it. I hope this cleared up some misconceptions. And as a reminder, we do these Zoominars the third Friday of every month, different estate and trust topic. So we hope to see you in the future. Thanks very much for coming and have a wonderful weekend.